Foreign Minister Wilfred Elrington was on no-show this afternoon, where a significant judgment was handed down against him in the Supreme Court. For the better part of a decade, Elrington has been embroiled in a lawsuit with the principals of Progresso Heights Limited, a development company owned and operated by Lawrence and Adam Schneider. This afternoon, Justice Courtenay Abel ruled in favor of the father and son duo.
He ordered that Mr. Elrington had no lawful right to register the caution, and the Belizean people should know that Mr. Elrington registered cautions on over 100 parcels of land. The judge says he had no right to do that, lawful right to do that, and he ordered $1,000 for each one of those parcels that a caution has been on. On top of that, he ordered Mr. Elrington to pay $119,000 US, which was specific loss that the company had suffered, so that comes up to over 300,000 Belize dollars against Mr. Elrington. In addition, he found that he should pay costs to the company.
The case against Elrington, a shareholder in PHL, goes back to 2010 when he proceeded to place cautions on as many as 100 parcels in that subdivision. The Pickstock era representative maintains that the Schneiders acted outside of the law when they failed to comply with the requirements of the Companies Act. In his arguments, Elrington referred to the Articles of Association that govern Progresso Heights Limited.
They are saying that they had, Mr. Schneider had said that he had authority to speak on behalf of the company by virtue of the provisions in the Articles of Association. But again, the Article of Association gives him no such authority. So really and truly, the very legal and technical position that we are taking is that the company, Progresso Heights Limited, is not properly before the court. It has given no authority to have action taken, and it has authorized no one to give evidence on his behalf.
Elrington's 20% stake in the company, in his words, constituted an unregisterable interest, thereby allowing him to proceed with the placing of the cautions. Setting aside that legal position, Justice Abel found that the caveats were intentionally placed to hinder the sale of those parcels.
The court accepted our argument that Mr. Elrington intended to cause economic loss and damage to this company. As I have said before in the media, we had a witness statement from somebody in the registry who was going to give evidence, did not turn up to court, but her evidence was going to be very clear that Mr. Elrington went to the office and threatened the people in there that they dare not remove the cautions that he had put on the land. Well, finally, the company has been vindicated. He acted unlawfully, and he has now got to pay the price of loss to the company as well as costs.
In a previous interview with News 5, Elrington rationalized the placement of the cautions on the properties by saying that Schneider and his son were attempting to frustrate the accounting process in order to slight him of his proper share of the company's profits.
We have not been able to get anywhere with the American directors because they have obviously been encouraged to try as long as possible to prevent me from being able to get a proper accounting and my proper share of the profits. But there are legal means that exist that I could resort to deal with that sort of situation. And one of the easiest was to simply place a caution on the properties so that they could not be sold.
Senior Counsel Eamon Courtenay attributes Elrington's actions, which have effectively stalled the sale of those properties, to a contrasting characteristic of persistence.
Mr. Elrington has a streak of stubbornness that is not based on law, logic, or reason. It is an irrational approach to things. He clearly hates Mr. Schneider, the people who own this company, and I do not expect that he will act reasonably. I do not expect that he's going to act rationally. He's going to have another appeal, and I would predict that he's going to lose. The judge just wrote a 74-page judgment. You heard the judge. He said he bent over backwards trying to find a way to rule in such a way that Mr. Elrington could not be found liable for the damages and could find none. It was an absolutely unlawful, roguish behavior of Mr. Elrington.
Reporting for News 5, I am Isani Cayetano.